I spent 7 years writing the book that didn't exist on how to litigate brain injury cases because the world needs it. There are 5.3 million Americans in the United States with a permanent brain injury, and every lawyer who represents them has no playbook until this year. I'm Taylor Ernst, 2024 California Lawyer Attorney of the Year. Got a $63 million verdict, literally wrote the book on brain injury litigation called The Ernst Way. I did 300 consults with other law firms last year on their TBI cases that weren't our own. We've tried enough cases and worked on enough TBI cases that all we focus on, it's all that we do. And what we are trying to do is help raise the bar of TBI cases across the country. I spent 7 years writing the book on TBI litigation, and I wrote the book that I wanted and I needed when I started. But let me step back a second. I can remember being 2 a.m, reading through documents, and the defense would dump these complicated medical journals and treaties and all these papers on me. I'd have no idea what I was reading. I didn't understand it. It would be late at night. I'd be looking for resources that could help me understand it, and there were not any. And so I'd take notes year over year of different types of things that I was working on and how I could figure out what would be just a little more helpful to me. And I wrote the book that I needed. I actually had a lot of feelings about even releasing it. There was quite a few lawyers in the industry that told me I should keep it to myself because they were my private notes. They were notes that I learned in depositions, in TBI trials, and everything that I ever did, I collected. So I'd be in trial and somebody would do something amazing or really bad for one of my experts, and I'd write down what happened and what to do next time. And I'd take that information and I just kept collecting it and collecting it and collecting it. And then over time, other lawyers would ask me, well, how do you solve this issue? And I'm like, oh, I've dealt with that in trial. Oh, I've dealt with that in depo. I know, you go here, here, here. And pretty soon it was 1 lawyer a week that would ask, and then 2, and then 4 and 5. And now it's like 7 or 10 lawyers a week reaching out to me. And pretty soon I was like, I can't keep taking this volume of phone calls. I need to do something better. And what better became was taking all my notes, putting them all in one place, and then cleaning them up so it was easy to read so that I could give all the pain and problems and awful things that I went through. And it's very clear, the 7 years I spent writing this book, a lot of it came from pain and money and mistakes that I made of me literally writing down in the middle of trial, I'm never gonna do that again. That just cold-cocked me. That was awful. Like, I don't want that to happen to any of my cases in the future. And I'd write that down, and it became a methodology of how we set up TBI cases based off the truth of the client. You fall back on the truth, and there isn't anything you end up worrying about in the long run, because if it's the truth, there isn't a bad fact that can happen to your client that you can't explain. Let me give you an example. When I had a client one time that called me up on the phone and told me, yeah, hey, I've got this problem with my case. And I said, tell me what the problem is. And what I ended up falling back on is I didn't solve the problem by preventing the information came out. I found out why the client did the thing in the first place. And if you know why the client did the thing in the first place, it isn't a problem because you can explain it through their brain injury, explain it through their character, or explain it through a technique that tells the jury and inoculates against the bad problem in the first place. So every week I end up talking to 7 to 10 lawyers about their brain injury cases. And the reason I end up talking about their brain injury cases is I've gone through so many consults. I think we did 300 last year. That's not our cases. That's consults for other lawyers on their cases to help them how to do better on their TBI case. And what happens is it isn't the lawyer doesn't know the medicine. It isn't the lawyer doesn't have the right experts. More often than not, it's a gap on how to take the medicine to actionable evidence that'll make it significant at the time of trial. The lawyer knows what a brain injury is. What they don't know is how to make a brain injury significant to the jury and the defense lawyer. That's the game. It's simple when you say it. It's hard to actually execute. To give you an example, one of the most painful things that happened to me in my last trial is I was so focused on proving the brain injury and then providing significant value to the jury that I had a disconnect where the jury directly told me about it after we got a pretty great verdict. The jury in the hall told me, yeah, we saw the brain injury on the scan, but it looks so small. And I remember just being absolutely stunned because if you try and settle the case, the insurance defense thinks the finding on a scan, specifically T2 flare, which is a type of scan for an MRI, is really significant. But to a jury, it's just one little dot on the brain. And if you compare the one little dot to the whole brain, it's a very small percentage of the brain. And the jury had heard a bunch about the problems he was having day to day and looked at the little dot. And then in the hall, they're like, yeah, this is after the verdict. They're talking to the lawyers after, and they're like, yeah, we heard all the brain damage problems he was having. And yeah, he really had brain damage and it was really significant. But then you showed the MRI and it looked so small. And I remember just being stunned because in the brain injury world, a positive finding on a scan is a really significant finding. And often those cases will settle where the jury didn't think it was a big deal. Like we could have not shown that MRI and the case might have actually gotten a bigger verdict. And so when circling back, it's not a knowledge gap. It is a execution gap. It's how to take the knowledge of what a brain injury is and have a step-by-step guide to explain it to a jury. And that's what the gap is that the lawyers have almost more than anything else when they talk to me. Is they'll say, hey, I've got an MRI scan and I got a neurologist and I got a neuropsych. Here's all the reports. And I'll say, what's the client's biggest problem? They go, I don't know. Why is it a big case then? If you don't know what their biggest problem day to day, how do you prove it to a jury? And they're like, my experts will prove that. I'm like, your experts are gonna stay in their lane and be able to talk about what their expertise is. You need to give the experts better evidence. And that's one of the things that we talk about the most in the book is we have a framework in the book called Gather, Focus, Reveal. And Gather, Focus, Reveal is based off you do not know enough about your brain injured client to be able to focus it down to what are the things are that are objective and provable. And then how do you take those objective findings and translate them into real world functional deficits? Every area of personal injury litigation has different focus. They have a playbook for auto cases. They have a playbook for medical malpractice. They have playbooks in a lot of the different areas. Then they even have CLEs on the, hey, you buy this set from this group and you end up with the playbook. There wasn't one for brain injury litigation. And the reason I feel so strongly about it is I wanted there to be one because it's what I needed. And so when I wrote this, it was almost a cathartic thing for my earlier lawyer self of what I needed at the time when it was 2 a.m. and I didn't understand the medicine and I'm Googling and I can't figure out what I need to know. And that pain is still so real with me. I remember the helplessness and uncertainty and knowing I was going to let my client down if I didn't understand this and having absolutely no one to call or how to figure out how to approach it. And the medicine will change over time, but the idea in the book, the Gather, Focus, Reveal, is so steeped in what the truth is and how to present the truth that it doesn't matter that the medicine changes over time. It's a fundamental philosophy that once you understand, you don't build TBI cases, you reveal them because the truth is already there. The client had an injury. They are already having problems with daily life. You just need to know significantly more about your client in order to do the right thing for them. I remember the first time a TBI case landed on my desk. I just recently passed the bar. It's a file that no one else in my office wanted this file. Frankly, the client was very difficult. He talked a lot. It was absolutely impossible to get him on the phone and not talk to him for 45 minutes or an hour. Don't get me wrong. I love talking to clients. I learn stuff, but he had a specific type of brain injury where he would consistently end up on tangents. And so he'd start talking about You'd start telling, hey, what's bothering you about something? He'd start talking about that, and then he'd be talking about a dog, and then he'd be talking about his newspaper that he got on Sunday, and then he'd be talking about a baseball game. It was unbelievable how much time you'd have to spend to get any information out of him. And it ended up on my desk because there was no positive MRI. He was self-employed, and he was hurt. But in the medical records, there wasn't a lot of information about how he was hurt. And so it was the classic problem that you run into in TBI cases where there will be some evidence in the medical records of concussion, mild TBI, unconsciousness, something. But then past that, there isn't a lot of documentation about the dizziness, the forgetfulness. Sometimes, depending on their acute rehab and stuff, there will be, but a lot of times there's not. And so what do you do? And I remember talking to my dad and saying, I believe this guy. I don't think he's making it up, but man, he's so difficult. What do I do? The medical records aren't that supportive. We've got the experts. What else? And my dad just looked at me and he's like, do you believe him? I'm like, yeah. And he's like, the evidence is there then. And I said, what do you mean? I'm like, we need to work this up? He's like, you don't work it up. The evidence exists. You just need to find it. And that became the underlying basis and philosophy for almost everything we do, is when you think you have enough evidence to go to trial, You don't. And we even talk about this internally as a firm, is the whole framework that became the backbone of the book is you need to know significantly more about your client than you think you do. And I don't mean, hey, have 5 stories and some lay witnesses. People say, hey, we need some additional lay witnesses to be ready for trial. Is you want to have so much information that there's nothing that the defense can do that surprises you in a way that you can't deal with. To give you an example with this client that had these injuries, after I started talking to the people around him, he was one of the smartest people. He tracked bills that went through Sacramento and then explained them at a 7th grade level. And the intelligence that's required to take a bill written in that complicated lawyer language and then explain it as a 7th grade level, I know lawyers that can't do that. And he had such a high level of intelligence beforehand where afterwards he was having to outsource that, hire people, and he was trying to even explain what they're supposed to do and couldn't even do that. And his memory and intelligence just was such a different level that it became very obvious to us that we started gathering all these additional facts that were outside the medical records and then being able to talk to our experts and talk to other doctors and talk to his treating doctors about the problems that he was running into with his work. And it became something that was grounded in the truth of his reality. And once you understand how to take even the most difficult, verbose, complicated clients and apply the systematic methodology, you don't worry about whether the case settles or not anymore. And I know because I've been there. I've been sitting with the mediator in a room or now on Zoom or whatever you are, and you have that deep fear that you're like, oh man, I really hope this case settles. After discovering this framework, gather, focus, reveal, and you get all this additional information, you don't care if it settles. And that's just such a remarkable statement because I can remember being like, I really got to settle this case. If you set up the case right and you know you can prove the injuries at trial, you don't care if it settles anymore. And it is the most strong statement you can make at a mediator who they feel it. They're just like, you really don't care if this settles, huh? And I'm like, I want the best deal for my client. I want to get the best number I can. And I'm going to bring it to the client and say, hey, here's what your net is. Sign off on this. You're either instructing me to go to trial against what your net would be, or we'll settle the case. It's the client's choice. However, the confidence I have in the ability to present my case on behalf of my client because of this methodology detailed in the book gives you conviction that you can't fake. So the thing with conviction, it's something I want to take you back to is when lawyers reach out to me, the 2 most common questions I get are, what expert do you use? And what do you think the value of this case is? And I think they're fundamentally the wrong question. Let me explain why. When a lawyer calls me up with what they think is a really big TBI case, and sometimes they are, sometimes they're not, that's a topic of a different video. What they're really asking me is, what number do you feel conviction my case is worth? Or in terms of the expert, if I hire this expert, it will reduce my uncertainty and make me feel more comfortable that my case is a good one. That's called borrowed conviction. It isn't earned conviction. Earned conviction is when you know down at your core that you're going to be able to explain this to a jury. Example that I sometimes talk about on stage, TBI Med Legal, I know I talked about it. One of the things that comes up is we had a client that had a really significant brain injury, but there wasn't a lot of medical records supporting it. And he was still doing things day to day. There was some doubt on our trial team until we went and met with him in person. And we're meeting him in person. And one of the lawyers showed up that's worked with him for years. And the client just looked him dead in the eyes and said, who are you? And it was a earned conviction moment where we watched in real time something he absolutely should know. It hurts his status. It's embarrassing. The lawyer's like, I've worked with you for 3 years. And all of a sudden the client doesn't know who he is, where that level of certainty that this client really has a significant brain injury that affects his daily life can't be borrowed. I can't call up a lawyer and say, how much do you believe this client? And they say, I believe him 100%, and then feel that same way. That's borrowed conviction, where earned is you literally watch the deficits happen live. It's the reason that all the lawyers and trial guys are always like, you gotta go to their house and you gotta meet with their family and you gotta do this. What they're actually telling you is you need the earned conviction that everything that you are proving to the jury is fundamentally true. And it goes back to the whole concept of until you gather enough facts, focus them down, and then reveal that truth to the jury, you don't have the earned conviction. It goes back to the concept of, is it something that a lawyer's asking me, hey, how much is this worth? Or what expert should you use? They want to borrow conviction. They haven't earned it. And it's the reason that when the defense is like, hey, we're going to offer you $1.5 million. Doesn't that sound like a great settlement? And I'm like, dude, that case is worth 10. And they're like, well, 1.5 sounds pretty good. I'm not sure if I believe the client or not. There's some issues with the case. And then they settle it, which frankly, just 3 weeks ago, I had a client that was like, we're thinking about bringing you on. I said, okay, whatever you want to do. And he's like, he called me up the next week and said, I settled the case for $2 million. I'm like, okay. He's like, what do you think it's worth? I'm like, you don't want to ask me that. He's like, why? I'm like, you know the answer. You know what I think. And he's like, yeah, I know. The reason he could have got a lot more is he didn't follow the framework. Looking at just the medical records and one of the reports he had, there was significantly more value on the table for him if he followed the gather, focus, reveal framework because of what the client had gone through. He settled it cheaply because he had borrowed conviction of what he thought a good number was, irrespective of what the facts and truth actually were. There was a specific moment that I realized I needed to release the book, and it was not what you'd think. It wasn't some giant victory or big verdict or giant settlement. None of that. It was a moment where I was in a deposition, or frankly, I was actually referencing something in the book myself. And I'd had a lot of doubts about whether we release it. We actually finished writing the book in early 2025, and we didn't release it until 2026. The reason that we did that was what I was grappling with is this is all my secrets. This is everything I know about TBI litigation condensed into a framework to teach other lawyers how to do it. And I get asked, why would you share all your secrets? Why would you tell everyone how to do what you're doing? Isn't there a big competitive advantage? Can't you make a lot of money just doing it yourself and not telling everybody else? And the answer is probably. But I don't want to be the lawyer that everyone thinks is the king of TBI litigation. I want to be the lawyer that makes all the other lawyers the king of TBI litigation. I don't want to be Luke. I want to be Obi-Wan that's handing out lightsabers to everybody else to say, hey, here's the framework. Here's what I earned and all the pain and money and time and effort and 2 a.m. of this is the framework that if you follow will work and you can help take care of clients across the United States. Whereas if we just do it ourselves, we only can help the ones we represent, which that's just not enough change for me. What kept happening in my cases was the framework kept being shown to work over and over again, no matter what part of the case I was in. It would be right before trial and it would happen and the framework would work. It would be right in trial and the framework would work. It would be right at the beginning of the case. We haven't even filed a lawsuit yet and the framework would work. We'd be in situations where I'd be gathering more facts from a client and they'd tell me, they'd literally say out loud, oh, this isn't in the ER records and I'm not sure it's important. And it became such a joke within the office. As soon as the client says, I'm not sure this is important, it 100% of the time was important and it would be related to their brain injury. Brains literally define everything we do. Working memory, vision, sight, taste, smell, hormones, everything. And when the problem develops significantly in a way after the injury, there's only so many things that it can be. And being able to decide if it's related to the brain injury or if it's psychosomatic or whatever it is, it's something that you need to give this information. You need to arm your experts and arm your doctors with the information and the truth of what your client's experiencing. To give you an example of that, we had a client that used the famous words, I'm not sure if this is important, and then would tell us about a significant vision problem. And just so the lawyers out there who know, 60% of the brain is dedicated to vision. It's the entire back part of the brain. If there's a significant trauma to the back part of the brain, there almost always will be some vision issue, whether it's double vision, blurriness, convergence insufficiency, needing different levels of glasses. It's actually something you should always look at in your cases is the client, if they have glasses or contacts, literally will end up going to an eye doctor 2 weeks after the incident and being like, yeah, my glasses prescription is this and that doesn't work anymore and I can't read anything anymore. And they're like, oh, when did you get your eyes checked before the thing? And it's like 2 weeks before the incident. So they'll have 2 weeks before the incident, their eyes are checked and they have fine. And then 2 weeks after the incident, they have a new prescription. It comes from the fact of all the problems that happen with the back part of the head. And so we had a client that told us, hey, I've got this problem with my eyes. I don't know if it's related, because the client doesn't realize eye problems are related to a brain injury. And so they just think, hey, I've been having all these issues reading and I can't see anything and my glasses don't work and I've got 6 pairs of glasses because I keep losing them and can't remember and none of them work. I don't understand what's happening. And those can be some of the best facts for day-to-day, showing the jury, you bring the glasses. Hey, try these glasses. You see it, you put them in evidence. It's fundamental visual proof that inoculates against the silent injury that all the defense lawyers know and try and bank on, that when the client walks in, takes the stand and communicate, everyone's like, well, do they really have a brain injury? And you have to have enormous amounts of facts to overcome that. The other interesting thing about this gather, focus, reveal that's becoming the backbone of TBI litigation is the concept that it isn't just work for us. It works for other law firms that are doing the same thing. To give you an example of how well this works, at TBI Med Legal recently, I had two lawyers, some of the most famous in the country, Bob Simon being one, John Romano of Florida being the other, literally both independently. We'd given them examples of the book. And I didn't even ask them, hey, what do you think, to my face? I heard it from other people that said, hey, they're calling it the Bible of TBI litigation. And it wasn't me asking them to say it or comment on it or any of that. This was two independent people, both asked, what do they think? And they both said the same thing. That isn't an accident. That's something that happens because they recognize this framework that we teach in the book is so grounded in the truth that once you understand it, you can execute it on your TBI cases in a way that everyone knows who's litigating against you, that the client evidence is grounded in the truth and you're building bigger cases, not because you're building the case and trying to make it something it's not, but you're just revealing the truth of what the injury actually is. Other than lawyers calling it the Bible of TBI litigation, what the people are doing is I talk to them often enough that I know their responses in real time. When they tell me what they're doing and I say, no, you need to go gather, focus, reveal, and focus on this. And they say, oh, and then I hear back from them 6 months or a year later and oh, that works so unbelievably well. It isn't us doing the case for them. This is us giving our framework away to other law firms for them to execute. We consulted on 300 cases last year. That doesn't include our own cases we litigated and tried. That's just cases that we said, hey, you're going to spend an hour with Taylor. This is what you're going to get. They get that, and then they go run it on their own. And after 50 of them, I was getting a little more confident that we were right. After 150, after 300, it's just pattern recognition at this point. I've seen so many TBI cases that I doubt there's a lawyer that's done more consulting on TBI cases in the entire country. We're on track to look at 1,000 this year. And we can't take that many. And so if we're going to scale the ability to raise the bar across the country, the entire goal is to give these tools out to other lawyers to do a better job taking care of their clients. This book isn't about selling copies. This book was written for me when I was a young lawyer and didn't know what to do. It's the framework all in one place, all the 7 years of pain and difficulties I went through. I'm trying to give it to other lawyers who can help their clients without going through the same pain. I wanted other people to have the frameworks that I didn't have access to when I was a young lawyer, and I know we can do it better together. The biggest lie in trial advocacy is that you build the case. Trial programs, trial advocacy programs, and how to learn how to try cases better are all designed around the word build. And that's focusing on something that doesn't exist and bringing it into existence. That's not the goal. I think it should be reveal, which is excavating what already is there. The empathy is already inside the juror. All you're having them do is locate it. This not only works with our client and our experts and our lay witnesses, this actually works with defense witnesses as well. Let me give you a story that happened just a month ago. It's a case that's no longer in litigation, so I can talk about it. I'm face to face with an extremely well-known defense expert, testified hundreds of times in trial, and it becomes very obvious that there's a fact that the expert has been trying to skirt around. It's not in his report. He tries to downplay it, but he finds out that I know. And then I'm questioning him about the thing he doesn't want to have to admit. But when he knows I know, I'm just excavating the truth. And he has to admit he's given these long, paragraph-long answers. And for you trial lawyers out there, you know what that means. I ask him again and again and again. And probably on the 6th time, the defense lawyer is saying, you can't keep asking him this question. I said, I want a clean answer. And the defense expert, to the defense lawyer's dismay, finally answers the questions clean. The defense lawyer's face, literally their jaw drops open. And I'm going to remember that forever because it was something that the expert knew when he gave up that fact was going to change the entire course of that case. The specific fact that changed the case was one that is going to require that person to be cared for the rest of their life. It was something that made the defense life care plan go from 0 or 50 grand or 100 grand to the defense expert was admitting that the life care plan now is going to be $3 to $4 million over the client's lifetime because of the one thing the defense expert said. And it didn't come from me building about facts of what was in the defense expert report. It came from proving what was already there that the defense expert didn't know about. But once he realized it was a fact that was in the case and he just hadn't reviewed it yet, he had to give it up. And then you get to ask the fun follow-up question, say, did you pick what you reviewed? And he says, no. Who picked it for you? And he's like, well, did the lawyers pick what they give to you? And he's like, well, and he hems and haws, but then has to admit yes. And so all of a sudden, it's the defense lawyers that are the bad guys for not giving him the information that helps us. And it changed the entire course of that deposition. And frankly, the defense called up the next day and said, we need to work this out. And that case settled a week later. So what's that teach us? It teaches that when you try and build something with an expert, it's persuasion. It's trying to do something that inherently is antagonistic with the other person, where if you're just trying to seek out the truth and reveal what's already there, you get experts that they're real doctors. They have real credentials. They've worked way too hard to be pushed around by one lawyer or another, and they just want to tell what they know. And you find that alignment, and all of a sudden it doesn't matter who paid them. Not everyone. There definitely are experts out there that are going to hold the line no matter what you do. But there's a number out there that actually will just say, you know what? Yeah, there's a real serious brain injury. And yeah, they're going to need care for the rest of their life. And yeah, they have functional deficits. And I think it's more this, but you're not wrong. It's also this. And that changes the entire outcome of the litigation, where the defense lawyer will then literally write a letter and be like, this is a case we don't want to try anymore. I consult with a lot of lawyers a week. 7, 10 lawyers reach out and ask me about their TBI cases, and invariably they have depositions they want me to review. And so I'm looking at a lot of expert depositions. And why does this matter? 95, 99% of depos I read for other lawyers are all adversarial. They're building their case. They're trying to do gotcha moments rather than trying to reveal what's already there. It doesn't work. And to give you an example of how much I know this doesn't work is I can read the depo and tell the lawyer was following a script, because there'll be answers that they don't follow up on. And if they're trying to get to the truth and reveal what was actually happening, they'd follow up, and they don't. You can tell they're just checking boxes. They're just reading from a script. And inherently, when you are trying to just build a narrative and build your case and trying to make it look good for your side, you're not finding out what the expert actually thinks. You're going to get blindsided at trial. And frankly, you're not taking the depositions in a way to really find out what the core issue is. It's a mistake. And I know this is a mistake because I used to do it. And it took me a long time to figure out how to break myself of it and try and just figure out what's the truth of what the expert really thinks and what's the foundation for that opinion. And all the lawyers talk about that, but really find out what the truth is, and you can build much stronger cases using this framework. So let me give you another example. I talked about experts on what build looks like versus what reveal looks like, but dealing with a client, we had a client that had a TBI and she was a masterful chef. And you don't even find that out in the medical records. That's not in any medical records ever. But you can all of a sudden, if you ask the right questions and try and reveal what the core concept is, rather than try and build the story of the TBI, don't do that. Find out what's changed. What's Thanksgiving look like? What happens when everyone comes over to your house? And they'll tell you stories how everyone used to come over their house and they'd be in the kitchen with 12 pans stacked around, and they'd have the mashed potatoes and the gravy and the chicken, and they'd be doing all these things. Where now you ask about what Thanksgiving is, and it's the person who used to be in charge of it all, the ringleader, the matriarch. Instead, it's frozen meals. And they're just consistently peeling off the plastic, and that's what they're putting on the Thanksgiving dinner. And you can feel the depth of that story that doesn't come from trying to build a good TBI case. Frankly, the lawyers that are trying to build a TBI case won't find that story when it is one of the most powerful components of the whole thing. Give you another example. When you're interviewing the client and you're trying to figure out where their significant deficits are, the lawyers are so focused on building a brain injury case that they'll ask them about dizziness and eye problems and balance, where what they should be asking about is the human story. Tell me about who you were. Tell me about your life. What were your goals? What were you trying to accomplish in life? How were you dealing with your family? What did a normal Saturday look like? you start telling those human components of the story, the brain injury will show up. I promise you that. But you find out what the real day-to-day life looks like. And then as a sub point to that, where the brain injuries change stuff, and you are going to build much stronger stories rather than trying to build a story about dizziness, you just talk to them and reveal what their life looks like, and dizziness will show up. So what's the most interesting about this build versus reveal skill is it's fundamentally a question of you versus the world versus us trying to solve a problem together based off what both of us recognize is true. And when you start aligning yourself with trying to figure out what the truth of the problem is, take your ego out of it and say, okay, what's really the issue here? You're going a level below what persuasion is. Persuasion, I was telling a little girl the other day, she was talking to her mom, and her mom's like, she's going to be so great of a lawyer someday. And I said, why? And she's like, she argues with everyone. And the mom said, what's the secret to being a good lawyer? And I remember telling the mom, the secret to being a good lawyer is you lay out the facts in a way that there is no argument. You're on the same team. There is no arguing. There's no persuasion. It just is. And it's what everyone discovers that should happen. Construction's the amateur frame. That's when you build something. That's when it's you versus the world. Excavation, trying to reveal what's true, is the master's reference. That's when you're looking at a series of facts that no matter who you tell them to, whether defense expert, your witness, a jury, they look at the facts and say, this is the truth. Your only job is to stop building and create the conditions for what's already true to be revealed. 300 cases, plaintiffs' firms from California to Florida, and almost the same 5 things are wrong in every single one of them. When you look at 300 TBI cases from other law firms, it's no longer just a number, it becomes a data set. When you see 10 files, it's individual cases. When you see 50, you start to notice some similarities. When you see 150, you start seeing the patterns. When it's 300, you know what moves the needle. The 5 things are the wrong imaging, missing witness gaps, arguing damages with spreadsheets, expert lineup that's missing 1 or 2, and the last one is no governing disagreement. So the wrong imaging, this is one that I could talk a lot about, and I literally wrote an entire section on it in the book. They will get a CT scan and it's negative, and they will get an MRI scan at some point, and they will misunderstand the wording in the MRI or the timing of the MRI, or they will get an MRI that's the wrong magnet strength, or the slices aren't close enough, or it won't have the certain parts that search for the most important parts of the MRI. The number of times I look at an MRI for another firm and they will give me a radiology report and I'll say, where are the films? And they say, we don't have the films, is gigantic. Probably 80% of the time I'm looking at cases for other firms, they won't have the actual films and they'll be relying on a radiology report. That fundamentally is a mistake. You want to always get the films. Something that no matter what radiologist you have, they will say it's more of an art than a science. The concept of looking at films and determining what is related to TBI and post-traumatic is complicated, and you want as much data as you can get for your experts. If you are just gathering the radiology report that another radiologist used, literally you're playing telephone. You're getting a report and giving it to one of your experts to read the report. Don't do that. Let them look at the actual images. They cannot tell you how helpful it is where we will have an expert find something that the other expert, when they're deposed later on, literally will admit that they missed. It happens more often than you think. The other thing is sometimes there aren't enough scans done. Sometimes one of the more telling parts of a brain injury is having a trophy in the brain, which is part of the brain shrinks a little bit from the brain damage. And you can see that over time. So sometimes there'll be a very early MRI, or sometimes there will not be an MRI at all. When you need that MRI and figuring out where it is in relation to when the incident occurred and trying to find out what the brain should look like versus what it actually looks like can provide some really valuable evidence that sometimes the defense experts can't argue with. And then there's the standard imaging that should be done on every brain injury case. SWI, DTI, volumetrics, those types of things. If you don't know what they are, feel free to ask. We'll give you the places that you need to get your doctors to look at, because it's just data points. Sometimes there's nothing there, but sometimes you can make your whole case around evidence that is on a scan. It's black and white. And even the defense experts sometimes will look at it and say, you know what? This looks like a sign and symptom of a TBI, then we can't rule it out. Give you an example of this in practice is we had not just the radiology report, we had the actual films. The defense just got the radiology report, and their defense expert's opinion was, I don't think there was anything more than head injury, but there was no concussion. And I said, did you look at the films? And the expert said, no, I just looked at the report. And I pulled up the films during the deposition, said, hey, Dr. Neurologist, take a look at these. Did you look at the brain ones? He said, the brain I think was unremarkable. And I said, you said no concussion. He's like, yeah. And then I pulled up the films that showed not only the brain, but also there was fractures down both sides of where his mandible was. And I said, doctor, did you see these mandible fractures? He's like, oh no, I wasn't given that. I said, there's fractures on both sides of his face. And he's like, yeah. I'm like, do you think there was enough force to cause a concussion? He's like, yeah. I'm like, that's a brain injury? He's like, yeah. All of a sudden, the case is totally different. The defense can't hide behind a report. The film's right in front of them. It's objective evidence. They can't fight you on it. The next pattern is missing witnesses. And this is a classic because the number of firms that have a ton of cases, or they've just got one or two and they're working it up like all their other cases, is they'll interview the client and they'll look at the medical records and that's it. And I say, what are the big problems that they have? And they'll say, I don't know, it's whatever in the records. And they haven't gathered enough information about what the spouse thinks. There's a huge percentage of people with brain injuries that don't understand what is damaged about their brain. And there's a ton of studies on this. If you ask defense expert these questions, they'll agree that one of the most common symptoms of a brain injury is not recognizing your deficits. So the spouse, if they're still working, coworkers at work, we'll have people that literally hire executive assistants that will say, yeah, follow the person around all day and basically act like their memory because they can't remember anything anymore. Like that's the testimony that ends up coming out. Why were you hired? Oh, they had a issue with their memory and I needed to come on to make sure I write everything down so they don't forget stuff and stop attending meetings. Like that's the testimony that comes out when you find these witnesses. But you only find those witnesses when you do the legwork. And if you just interview the client and do the medical records, you don't got it. Give you an idea about some of the witnesses that we've called in the past at trial that have been really helpful. We've called the person that they regularly see, like the butcher from the market. We've called the person that runs the laundromat. We've called their garbage truck driver. That was actually one of the most interesting ones. We called him as one of our very first witnesses in a case, and the defense cross was pretty funny because they're like, are you friends with them? And they're like, no. And they're like, do you know them socially? No. How do you know them? Why are you testifying in trial? Well, I've seen them every week for the last 5 years, and she stopped coming outside her house 3 years ago, and she used to bring me marshmallow treats on Halloween, and she can't do that anymore. And how do you know that? Well, I see her husband helping her get in the house when she comes home sometimes. Why are you here then? I got a subpoena and I want to tell everybody here what I've seen. And that testimony is just unimpeachable. And it's somebody that took a lot of legwork to find, but you find that witness and all of a sudden the defense saying, oh, they're in it for the money, or it's all about the lawyers working it up. That just goes out the window. We call those witnesses sometimes first or second in the case, and it changes the whole trajectory of the case because they're no longer wondering, are they telling the truth? They heard from someone that has no interest in the outcome. And the lawyers always ask me, what's the question you ask to find out about these witnesses? Is there a specific question? And we walk through the framework of how to do that in the book. But more than anything, the goal is, your sister or your spouse. We need those people that are close to you. But we also want a group of people that you don't know very well. These are the type of people, and I always frame it as that you might not even know their last name. You just know they're someone that you see now and then enough that they recognize you and have seen some of the struggles that you've been dealing with. To give you an example, we had one client one time that went to buy makeup at a store. The woman behind the counter saw her trying to buy makeup and saw her struggling. She came up and the client from the TBI had a stutter, and she started stuttering and trying to get out what she wanted to buy. And the woman behind the counter looked at her and said, "Where's your helper?" Basically saying, you have so much trouble communicating, you shouldn't be in public alone, and there should be somebody, basically your chaperone. And she said this to a 35-year-old woman. The woman broke down, cried, left the stuff at the counter, and never went back to that store ever again. And it was a witness that we went back to the store and found the person. You find a witness like that doesn't know them by name. They just say, oh yeah, that was true. That did happen. That type of testimony changes the way your TBI case goes into the jury. Pattern number 3 I see is damages argues with spreadsheets. And what that means is the lawyers will basically either get a life care planner or a vocational rehabilitationist about what job they should be able to do or can't do, and then put a whole bunch of big numbers together and basically put a big spreadsheet together and either hand it to the defense lawyer, the adjuster, or the jury. And they say, hey, here's this big spreadsheet, here you go. And I don't know any jurors or defense lawyers that tend to feel spreadsheets. You don't understand the human loss by saying, here's a bunch of numbers to consider. You want to lead with the emotional truth of what has changed in their life in a way, and then have the spreadsheet be like subpoint C. Like, you don't want the spreadsheet to be your piece of evidence. You want it to be, this was a doctor who used to do surgery in a way that he can't even pick up his scalpel anymore. And the nurses had to tell him, hey, I don't think you should still be working. He was trying to figure out a way to stop the tremors that he was having, deal with his epilepsy. And it ended up being that he got told by one of his doctors, you should never do surgery again. And he was making $800,000 a year doing those surgeries. Do you see how it's the sub point? It's not the spreadsheet that you push with. You lead with the story, and the sub point is just the backup of information that cements why that story is so significant. That's something that on almost every single case is never done right. And I know it because I always say, well, why shouldn't they be able to work in the future? Why can't they type at a computer? Why can't they stand? Why can't they fill in the blank about what they were supposed to do? And when you start really pushing back, most of the time, those spreadsheets don't work. Expert lineup gaps. This is one that's probably the most egregious, because what everyone does is they do what they think they need to do on every TBI case, which is neurologist sounds like neurology and sounds like brain injury. And so almost everyone hires a neurologist. And then it's kind of across the board. Sometimes they'll get a neuropsych, sometimes they won't. Sometimes they'll get a physiatrist, sometimes they won't. Sometimes they'll get a life care planner, sometimes they won't. Everything after a neurologist is kind of shoot from the hip. They sometimes do, they sometimes don't. And I cannot begin to tell you how wrong that is, other than the real focus should be, what are the deficits they're having day to day? And is there a specialist dealing with that? And everyone thinks because it's a brain injury, a neurologist is the one to talk about their day-to-day deficits. Sometimes, but a lot of the times it's not. Sometimes it's the speech and language pathologist talking about their inability to comprehend the world in the same way to communicate with the outside world. They're doing 3 or 4 times a week of treatment with this speech and language pathologist that's just saying cognitively, they're not the same. That witness is going to be better than your neurologist for functional deficit. To bring it all together, the expert lineup shouldn't be a series of checkboxes that you just say, well, did I hire the right experts? Check, check, check. It should be, do I have the experts that deal with all of the functional deficits my client has and talk about how they're going to deal with those problems over the rest of their life? We start asking that question, you're no longer going to have those expert gaps. One of the big issues I also end up needing to talk to you about is that the number of people that call me and say, who's the quote best expert I should hire for a TBI case? And that's the wrong question. And it's the wrong question because it misunderstands what actually drives the value of a TBI case is the functional deficits. Where are the deficits? And when I start asking questions about, well, what are their biggest problems? And the lawyer says, I don't know. How can you get the right expert when you don't know what their actual problems are? And the lawyer says, well, I'm not a brain injury lawyer. I need to figure out my expert so he can tell me that. I said, no, you've got it backwards. You need to find out where the biggest problems are in their day-to-day life and then go find experts that deal with those problems. You can't have the experts do the work for you. You've got to do the work and then find experts to support the work. So the expert gap isn't about checking the boxes. It's having the right experts in the right seats, given the right functional deficits that they can talk about why the story is supported by what the expert did. The most common expert gap that I see in the files is the lawyer doesn't know what experts to get. And they don't know what experts to get because they haven't done that many TBI cases, and they're trying to do what everybody else does on a TBI case. And because no two TBI cases are the same, you can't follow the pattern of someone else and have it work on your case as well as it should. You should figure out what you should do to have experts talk about the biggest problems of your client's life, be memory, be balance, be speech, be what is the thing that's really changed, and then find that specific expert to be able to provide the objective proof that circles back to fill that gap. All right, and here's the biggest one. No governing disagreement. This is by far and away the thing that I end up talking to lawyers about the most. And the question is this: in your case, what is the thing that if the defense understands, they will agree to your valuation? What the governing disagreement really is the lawyer should be able to say in one sentence what the jury must decide. If you do not know what the jury is deciding in one single sentence about what the whole case is about, you don't understand enough about your case. And the lawyer's inherent reaction to this is they will say, my case is, quote, too complicated to be able to simplify it down into one sentence. And let me just dissuade you of that right there. I did a case dealing with a toxic tort where he got cancer from oil in the ground that was there 25 years earlier, and his cancer was in remission, and we had all these complicated things to talk about. Different types of cancers, different type of blood, different ways that oil comes out of the ground, who put it there, all these complicated things, and it was against a gigantic company. We were able to do that into a single sentence. I've never been able to work on a case where I couldn't simplify it down to a single governing disagreement. And if I can do it in the most complicated cases where there's literally hundreds of thousands of documents, you can do it in a TBI case, period. A governing disagreement sentence sounds like this: a professional driver in a hurry didn't see the person that they backed over with their work vehicle, leaving them with a brain injury that impaired their ability to be a bank executive for the rest of their life. In that single sentence, now you understand anytime we're talking about what the speed was, why that's important. Anytime we're talking about a professional driver or safety standards, you understand why it's important. Anytime you understand where their head was, you understand why it's important. Anytime you understand what bleed or not bleed was in the head, you understand why it's important. Anytime you're talking about their job and whether they were good at it or why they get laid off or had to get an assistant to be their extended memory, you understand why it's important. All of a sudden, all the other facts that go back to that single sentence have context, and they no longer are out of order, or the jury hears them and goes, I don't know what to do with this information. And when a juror doesn't know what to do with an information, they forget it. The defense expert just testified your client's fine. Here's how to take them apart in 10 minutes. Most lawyers approach cross-examination like a boxing fight. They go in swinging. They try and knock them out with one gigantic question, and they think they've got the gotcha. That couldn't be further from the truth of how you actually need to do it. The expert handles it because they've seen every type of gotcha question 100 times before. They've been deposed 500 times. There isn't any question that you're going to ask them that's going to surprise them in any way. So you don't go in with a fight trying to land a haymaker. You go in trying to design systematically a way that their testimony falls apart. The framework's called commit, contradict, collapse, and it's the same in every expert type. The first one's commit. What you want to do is you want to get the expert to explain their expertise, their guidelines, their rule book, their principles. Every expert has one. It's the expert's methodology. It's how they go about reaching the conclusions. So often I see lawyers skip over this because they think it's not important. They're doing background and they think it's not where the real fight is. And so they'll skip it and they say, oh, you did it the standard way a neurologist does, or what did you do as a neurologist? And the expert will be very vague and they'll just go on to the next thing because they don't think it's where the value is. They want to fight. They want to engage and do the boxing, and that's not what you want to focus on. You want to focus on questions like, doctor, don't you agree a neurological examination requires a full and thorough, detailed history? Simple questions. Do you agree that spending adequate time to know that patient's entire history is important to getting the correct diagnosis? Is it important to follow your guidelines ethically? This might seem like throwaway questions, and it's why so many lawyers of cases I review skip it. But these are the most important, because if you get something where they contradict their framework, but you don't have their framework explained, you can't cross them well. They will dance out of it. You need in black and white. Doctor, it's important to do a full interview that is accurate, true, and you need to get that correct so that when later they have something that's incorrect from the clinical interview, you have the exact question and answer to completely collapse their testimony. You need them to commit to their standards in black and white so that when they are proven to be not following their own ethical standards, an hour or 2 hours or with the jury sitting right there, they can't wiggle out. So for example, there's a professional expert in a very large metropolitan city that is widely used by the defense, 80 or 90% used by the defense. To give you an example of this in action, I got him to commit. Did you review all the medical records you were given? Yes. Is it important for you to review every piece of medical records from the client to get an accurate representation of what the client went through? Yes. Did you review everything? Yes. Is it your ethical standards that you review all the necessary medical information before you come to your opinion? Yes. Fast forward 2 hours through the deposition, I say, doctor, isn't it true that the patient was unconscious on the day of the injury? And he's like, well, according to the hospital note, I don't think they were unconscious based off my training and experience. And I say, are you sure about that? And he goes, absolutely. I said, did you review anything that said they were unconscious? He's like, no. And I pull out a medical record, put it right in front of him and say, what about this medical record? Did you review that where it says on page 17 that they were unconscious? And he looks at it, looks at me and looks at it. And he's like, well, I guess I didn't see this record. Then I can say, doctor, but earlier in the deposition, you said it's important to your opinion to review everything. True. And you said you did review everything. True. Did you miss this piece of paper, or did you just leave it out because the defense paid you 25 grand and you can help their testimony by not looking at it? The next step is contradict. This step, lawyers combined it with collapse, which is showing how they violated their own thing. You don't want to do that all in one thing. You want to space it out. And you need to make the tactical decision of, do you want to do it in the deposition, or do you want to wait to show where they contradicted their own methodology with the jury sitting right there? The goal for contradict is you show that the doctor, by his own words, didn't follow his standards. You basically are showing that the doctor did junk science in a way to get to his opinions. You don't want it to be you and your narrative versus the doctor and what the doctor's saying. What you really want to do is, it's almost like holding up a mirror. You let the doctor explain what good looks like, and then you hold up a mirror and show the doctor what he did in the case and say, is this what good looks like? Because if the doctor's being truthful, they're doing one of three things. They're either minimizing facts about your client, if your client's got the brain injury, they are misrepresenting or omitting facts from their report or their deposition, or they weren't given all of the information. Because if your doctor and the doctor you're deposing both come to different conclusions on the same set of facts, it's one of those three every single time. The reason that there's these three things the doctor will do every time is it's one of those three things that contradicts what they say in the commit part. Is if they say they're following all the standards and they reviewed everything and they were detailed about everything that they were going to do, they can't do that and then come up with a fundamentally different answer than your expert if the client's got the TBI that you have the proof of. What happens when the expert contradicts themselves is there's an opening where they don't know what to do next, and they will look for the path of least resistance. So an example of this is I had an expert that said, your client had a mild TBI, but no significant long-term problems. And what I did is I said, you did a clinical interview. Yeah. Were you thorough? Yeah. This was stuff earlier in the deposition. And then I said, did you ever ask him if he catches things on fire? No, I didn't ask him that. Did you ever ask if he can drive? I didn't ask him that. Did you ever ask if his wife will let him be home by himself? I didn't ask him that. Do you think those are important considerations for a client who suffered a TBI? Well, and he'll start to realize that he's got a problem, and that's where the contradiction opens up. He's trying to figure out where to look good and save face and be truthful, and that's the point where you want to give him an out that allows him to look good by giving you the facts that you want. So the question follow-up would be, if you're really going to get him to contradict, and watch their face when they're doing this, their face tells you everything, is they'll say something like, "Doctor, I see in your report you didn't put a prognosis of what they're going to need in the future. These are the kinds of things that you weren't asked about, but asked about here. They're going to have long-term problems because of those 4 things we just discussed, right?" And the doctor will grab onto it like a life preserver and say, "Yeah, that's right." And just for you lawyers out there, that's when the defense expert, quite literally, his head will snap back or their mouth will fall open, or they'll like, because they realize their expert is no longer on the script and just saying what they need to say to look truthful and protect their own reputation. Now, when lawyers think they've got the perfect kill shot or the perfect ending of cross or the perfect way to really show the jury what happens, they generally go too far. And I always kind of view it as like the cartoon Acme hammer, a 2x4 across the face. You don't want to tell the jury what to think. The way the collapse works is you get the defense expert to commit, you get them to contradict themselves, and the collapse happens when you put a question that allows the jury to understand the expert's lying, misleading, or doing something they shouldn't have done that violates their own principles. You don't need to spoon feed the jury. The jury is really smart. They will get it. You just set up the right question and let the jury realize the expert isn't lying to the lawyer. The expert's lying to them. When the collapse happens, one of the biggest things that juries don't do is you need to make the moment bigger. Emotions happen slowly, and lawyers are intellectual creatures by nature. We like to read, we like to think, we like to try and solve things logically. And it is the biggest mistake when lawyers ask an angry question or try and do the gotcha moment after that collapse series happens. They rush it. What you should do is ask a series of very slow questions to draw out the emotional moment. You ask questions like, "Are you sure?" And then you look at the expert, and then you look at the jury, and you just wait. You should let the seconds become uncomfortable for you, because if they're uncomfortable for you, they're excruciating for the expert. Some of the best testimony we've ever got off the witness stand comes from not the question, comes from a 5 or 10 second pause where we're just staring at the expert who can't stand it anymore and starts filling the space and saying, "You know what I said earlier was not right, and I just must have made a mistake, and it's really this." And all of a sudden the jury's watching the collapse happen in real time. So to give an example of the collapse happening live, you get the expert to commit that he follows ethical standards, he has to follow all the rules. You get him to contradict himself that he said no evidence of brain injury, and then you walk up to him, and I'll never forget, I handed him 2 documents. One, there was a report that showed evidence of the brain injury, and another that showed that he deleted it. And he looked at me with eyes like he saw a ghost. He knew that I knew I caught him red-handed, and the jury was watching. Not only after the verdict, the jury told us that that doctor wasn't credible, they said it affected the entire credibility of everyone and made the jury mad, and it made it a much larger verdict. The concept of commit, contradict, collapse is so strong because it isn't based off trying to put your side argument forward. It's based off what actually happened. And because it's on that deeper principle, when you find evidence that supports it and you collapse it, that they didn't follow their own rules, inherently you're revealing a gap that emotionally the defense expert knows deep down exists. The contradiction in what they say is true and what's actually true becomes significantly bigger, and you can see the gap and the jury can see the gap, and emotionally the expert emits feelings of being caught, of being shamed, of doing the thing they know they shouldn't have done. They're getting their hand caught with the cookie in the cookie jar and looking at the parents being like, "Oh no, you caught me." And it's such a universal sign and symbol of emotional, "Oh no, they've caught me." The jury sees it and 100% of the time recognizes it, and that expert's testimony and other people associated with that expert are so harmed credibility-wise that one of the times we did a cross like this, there was no rehabilitation. The defense just stood up and said, no questions. So after you do commit, contradict, collapse, these are 5 mistakes that you can make that will make it not land well at both deposition and trial. So don't do these 5 things. You don't want to ask one question too many. You want the jury to sit with the most painful emotional part that the expert's going through. If you hurry it and ask a follow-up question, the emotional moment's gone. You don't want to get angry or adversarial. I talk about it in other videos, but basically only one person can be angry at a time. If you get angry, the jury doesn't have to get angry. If you're calm and the jury senses that the expert's lying to you, they'll be the ones to get angry. Number 3 is you don't want to try and get the expert to admit they're wrong. They won't do it. They've been trained, they've been through hundreds of depositions. Don't say you're wrong. It's just a mistake. Avoid it completely. Give them an out that helps you. Don't try and get the expert to admit they're wrong. They won't, and it turns it into a you versus them in a way that doesn't help the jury feel the emotional weight. You can't skip the commit. Everyone skips this because it's easy and sounds simple. If you skip the commit part of the sequence, you don't have the ability to really get the expert. Number 5 is you can't go too fast through this. They have to feel the moment of the contradiction that leads to the collapse. Go slow. Commit, contradict, collapse. It's the same system and every time. And the reason it works is built on the foundation of truth. If you get the expert to admit they violated their own rules, that's the thing that no juror watching won't think that they're uncredible afterwards.
This book has been 7 years in the making. For more information on how to get your copy, I added a link below. Let's raise the bar together. I'm Taylor Ernst. Thanks for watching.